All right, let's talk about a case that trips up so many people in Indian law, from first-year students to even some seasoned lawyers. It's all about audio evidence in matrimonial disputes, and it centers on one case that is constantly cited and almost always completely misunderstood. You've probably seen this floating around. The case of Alika Khosla versus Mathew is often thrown out as the definitive authority, the final word, establishing that an audio recording and its transcript are admissible in court. Seems simple, right? A clear, solid precedent.
Well, here's where this story takes a pretty sharp turn. What if I told you that this common understanding, this legal mantra, is just plain wrong? What if the actual legal battle in Alika Khosla had nothing, and I mean nothing, to do with a tape recording? Let's pull back the curtain.
So, let's do what every good lawyer does and get to the actual facts of the matter. It's time to set the record straight.
And there you have it, the big reveal. The 1996 judgment in Alika Khosla versus Mathew was not a landmark ruling on audio evidence. So the obvious question is, if it wasn't about that, what on earth was it about? Okay, let's look at the actual case file. The case was presided over by Justice V.S. Agrawal, and it was a divorce petition under the Indian Divorce Act. The central issue wasn't a secret recording, it was a request for DNA testing of fetal tissue to figure out paternity because of adultery allegations. So the real legal question the court was wrestling with was this: how do you balance a person's fundamental right to privacy under Article 21 against the absolute need for proof in a legal case?
So, if Alika Khosla is the wrong case, then what's the right one? Let's take a look at the actual legal framework that governs audio evidence in India.
The true foundational case, the one every law student really needs to have memorized, came decades earlier. We're talking about the 1973 Supreme Court case of R.M. Malkani versus the state of Maharashtra. This is the landmark judgment. It was here that the Supreme Court said, yes, tape-recorded conversations can be used as evidence, but, and it's a big but, they have to pass a pretty strict test first.
And that brings us to the core requirements. The Malkani case gave us a clear three-part test that is still the absolute bedrock for authenticating audio evidence in India today. Let's break it down.
It's really quite logical when you think about it. First, relevance. Does the conversation actually have anything to do with the case? Second, identification. Do we know who is speaking on this recording? And third, this is the really critical one, accuracy. The court has to be totally convinced that the recording hasn't been edited, doctored, or tampered with in any way, shape, or form. And building on that, the courts have added even more hurdles. The voice has to be identified by someone who was there or who made the recording. You need to prove the chain of custody, that the evidence was sealed and kept safe. And, of course, you have to actually be able to hear what's being said clearly. It's all about making sure the evidence is rock solid.
Now this brings us full circle, right back to that theme from the real Alika Khosla case, privacy. Because when one spouse secretly records another, it kicks up a huge constitutional question. How do you balance that person's right to privacy against the court's need for evidence?
Think of it like a set of legal scales. On one side, you have Article 21 of the Constitution, that fundamental right to privacy. But, and this is key, that right isn't absolute. On the other side of the scale, you have the court's duty to find the truth, and to do that, it needs relevant evidence. It's a classic judicial balancing act.
And the courts have been pretty consistent on this. They've held that inside a marriage, especially when there's a legal dispute with accusations flying back and forth, the right to privacy has to bend a little to allow for proof. The idea that the four walls of a home create an absolute shield of privacy just doesn't hold up in court.
So this whole debate has been going on for years, but it all led to a very recent and, frankly, very clear ruling from the Supreme Court that finally gave us a definitive answer on these secret spousal recordings.
In the 2025 case of Vibhor Garg versus Neha, the Supreme Court settled it. The court held loud and clear that conversations secretly recorded between a husband and wife are admissible as evidence in matrimonial cases. This ruling directly tackles the privacy argument and puts the court's need for evidence front and center.
But, and this is a really important but, the court didn't just give a blanket green light. It laid down 4 very clear conditions. The audio has to be relevant, it has to be clear, you have to prove it's authentic, and, crucially, the other side has to have a fair chance to challenge it. This makes sure that even though the evidence is allowed, the whole process stays fair and just. So, after going through all of that, what's the one thing you absolutely need to remember? What's the bottom line? Here it is.
While Alika Khosla is the wrong citation, the idea it's often used for is actually correct. Audio evidence is absolutely admissible in Indian courts, as long as you can jump through all those hoops to prove it's authentic and relevant, just like the courts laid out in RM Malkani and later clarified in Viborg Garg. It's a perfect example of the right legal principle being attached to the wrong case name.
And that leaves us with one final thought, looking to the future. All these legal tests were designed for an age of analog cassette tapes, but today, we live in a world of AI-generated audio and incredibly convincing deepfakes. So the next huge legal challenge is going to be adapting these old principles of authenticity to a new digital world, where you literally can't believe what you hear. How will our courts handle that? Well, that's a question for another day.